Hi, everybody. I know I can see we've still got a few people logging on to join us, but I wanted to go ahead and welcome you to our webinar, TCPA Litigation, Can You Be Sued for Sending a Text Message? I'm Molly Vidler, and I'm here with Tenstreet's General Counsel, the fabulous Shannon Wheeler. And for everyone who has made time in their busy day to be with us today, welcome and thanks for hanging out with us for the next hour or so. I have a feeling this webinar is going to provide a lot of value to you all. We hope that today you walk away feeling knowledgeable about serial plaintiffs, the risks of sending text messages without an opt-in, and how Tenstreet can help carriers defend themselves against a TCPA lawsuit. Before we get started, I did want to let you know that we are recording this webinar, so it will be sent to you within the next 24 hours. So if you get interrupted or have to jump off the call, don't worry, you'll get the recording sent to your email address tomorrow, and you can review it at your convenience as many times as you'd like. Also, as a reminder, feel free to submit any questions at any time throughout the presentation. You can do so using the text box under the questions section in your GoToWebinar panel. We'll try and answer as many as we can during our question and answer session at the end of the webinar if we have time. Now, with all of that out of the way, I'm going to go ahead and pass the mic over to Shannon and let her get started.
Awesome. Thank you so much, Molly. I appreciate it so much. Hey, everyone. It's great to be here. Thank you for joining me today to talk about the TCPA. So real quick, always have to give this legal disclaimer. The materials that I'm presenting is just for educational purposes only. This is not legal advice. As always, we recommend you consult with your own qualified legal counsel on all of the issues, laws, and regulations we talk about. And of course, we disclaim any warranties associated with the presentation. Okay, so let's jump into the TCPA. That stands for the Telephone Consumer Privacy Act. And by the way, I just want to give a quick shout out to Molly on all of these slides. She did a fantastic job on these beautiful slides. She just takes all of the boring legal information and makes it into a beautiful presentation like what you're going to see. So I just have to give her major props on what she does here with the boring legal slides that I put together. Okay.
You make it for me.
Oh, well, you do such a great job. So the TCPA, you've probably heard of this before. If not, it stands for the Telephone Consumer Privacy Act. It does apply to both telephone calls and text messages. And it applies if you are calling or texting any person within the United States. So even if you are outside of the United States or your dialer is outside of the United States, if you're calling or texting somebody within the United States, it is applicable. So this is a federal law. There are state TCPA-like laws, which we'll talk about in this presentation, but the main one we're focusing on today is the federal law. It is governed by the FCC, and there are private rights of action, meaning individuals can sue companies for violations, but the FCC can also get involved, and the FCC issues, regulations regarding it and also some guidance we'll talk about here in a little bit. So the big things that apply under the TCPA is that there are consent requirements, meaning that you have to have certain levels of consent to either text or call an individual. In fact, the entire intent of the TCPA when it was passed was to ban automated or pre-recorded calls except for when there was consent. But of course, since then it has evolved over time. Back when it was passed, there wasn't, I think it was 1991, there wasn't quite the amount of texting that goes on today. And now texting is definitely a preferred method of communication. Everybody knows that you get a text message on your phone. That's a really sort of intimate communication. The individual is gonna likely see it, which is also another reason why you need to be very careful in your texting. Okay, so the Telephone Consumer Privacy Act has certain consent requirements. It also has certain requirements regarding the National Do Not Call Registry, and we're going to go through those just briefly. Essentially, it says you have to check the Do Not Call Registry unless you have written consent, prior written consent. And so if you have written consent, that sort of exempts you from the check of that do not call registry. And we'll talk about that a little bit more. You also have to contact individuals during reasonable time limits. So that's between the specific regulations say between 8 a.m. and 9 p.m. of the particular individual's time. So not necessarily the time zone that you're on, but the time zone that the recipient is on. Also, no artificial voice recordings or calls unless you have explicit consent to receiving those. The big sort of thing that you will get in trouble with is that you must respect opt-out. So even if an individual initially consents, if they opt out, you have to respect that. You have to honor that. The big thing here is that it carries massive amounts of fines. So there's a potential for $1,500 per text or per call. And sometimes if you violate two different sections of the TCPA, you can have $1,500, and that's if they find it willful. There's a minimum amount of $500. So anywhere between $500 and $1,500 is sort of the range of potential fine associated with a call or a text. And if you don't get consent and you don't check the do not call registry, that is actually considered two violations. So one text, it would be $1,000 if it was on the lowest sort of fine, or it could be up to $3,000. So $1,500 per violation per text or call. There are state TCPAs that have fines associated with them as well, as we're going to touch base about. And of course, because of this playing field of private rights of action and high dollar amounts, those things, of course, come with serial plaintiffs and class action lawsuits. So we're going to go into those next. Molly, if you would switch slides. These are some of the recent TCPA litigation that I have looked up and pulled the numbers for you so that you can see what these add up to and just how big they get. These are settlement values for the most part. They do not represent all values like trucking companies and recruiting, but some of them do, and we'll go into that. In August of 2014, the Capital One texting case, you all might be familiar with this. It was the big famous case at the time. Nobody thought damages could get that big. It was heavily contested for many, many, many years and ended up in a class action settlement for $75.5 million against Capital One. This was the sort of the most famous TCPA case, which is why I included it. And then, of course, not long after that, in September of 2016, Caribbean Cruise Lines got hit with $76 million for TCPA violations. I think that was actually a settlement as well. So that just shows you just how big these numbers can get. And I've seen a $90 million one as well. I didn't include it on this slide, but these get very, very big numbers. I know you guys, we see these numbers in nuclear verdicts, and they're not numbers that we're sort of starting to get used to seeing these gigantic numbers. But within the TCPA realm, at least, these are very, very manageable risks. So that's why I show you these numbers before we talk about the risks. I point out the one against Lyft that happened in March of 2019. It was a $4 million settlement because those were specific to recruitment text messages. So, keep that in mind. Some of these others are just selling, but Lyft was specific to a recruitment text message. And then, these lawsuits have continued with large numbers all the way, up until now. I am currently aware of 3 TCPA lawsuits that exist against trucking companies that are happening right now that relate specifically to recruiting text messages. So that's why we want to be really careful with those and follow the rules, because they can end in a lawsuit. Two of those are pending. One of those ended in a $315,000 settlement. So that's not a huge, giant settlement figure, but as we know, or as you may know, that's just the settlement figure. That doesn't include the lawyer's fees that it took or the time and energy that it took to get through that lawsuit. And if you follow some of the things that we're going to talk about here, you can potentially avoid those kinds of needless lawsuits. So next page, I have put together a sort of the trend on TCPA litigation. This slide is the good news slide, and so many of you might look at this and you can see TCPA litigation, the number of cases brought are going down, drastically down in 2021 from what they have been. 2016 was sort of the height, and they've gone down from there. So never say that lawyers don't bring you good news. Here is my good news slide, right? I hate to say it, but this is the kind of good news lawyers come up with. So the trend is going down. I think the trend is going down because of compliance. Essentially, I think companies are hip to these high damages, and they know, hey, if we comply with these very, basic, simple rules, we know we can manage this risk. And so the numbers are going down because of that. Also, I will say in 2022, I looked at the trends so far. They are up from the numbers in 2021. Of course, we've got a few months to go left in 2022. I do expect the number for 2022 to be a bit higher than that number in 2021, but it won't be as high as 2020, I don't believe. So, so just keep that in mind. These cases are still being filed. And while they're going down, they are still being filed, but we can even continue to minimize those numbers with compliance. I do want to also qualify, if you go back just real quick, these are based on federal TCPA cases. These numbers do not involve state TCPA cases. Usually they're brought together, but sometimes they're not. So just a little bit of a qualifier there. Okay. So the next thing I want to talk about is a real world example of a serial plaintiff. This actually came through Tenstreet. If many of you on the call might be users inside the dashboard and might have seen a Tenstreet alert that we put up. This is what it related to. We had about a month and a half ago, back in July, a serial plaintiff email us. Of course, I've blacked out some names to keep confidential, the particular employees at Tenstreet, as well as the client that it related to. But this serial plaintiff threatened to sue both Tenstreet and our client for text messages, recruitment text messages that they received. This was the email that we received. It also came with a handy dandy, already put together complaint ready to be filed. It was 14 pages long, fully ready and able to be filed within, a couple of days after sending this. This was like the pre-little notice. And as you can see, it says, hey, I'm reaching out to you. I've gotten unwanted text messages. I'm gonna sue you unless you settle with me. And does a little math down here at the bottom and says what the potential value is of the this individual received 5 text messages. So the potential value is max value. What this individual thought that receiving those 5 text messages was $40,000. But of course, they were willing to settle for $9,500. This is clearly an enterprise, a job, if you will, for this particular individual. This individual is representing himself pro se and has filed many, many lawsuits. As soon as I got this email and the complaint, I looked at it and I thought, oh yeah, this is not this individual's first time doing this. I went and looked up Mr. Solis, and he had filed at the time about 30 cases against companies with almost an identical complaint. Yes, thank you, Molly, for changing that over. So he sued them all in the Western District of Texas. That's where he appears to live. Now, to date, at least a couple days ago, there were 36 lawsuits that he has filed. They are all TCPA lawsuits. He is representing himself pro se, and all the complaints say almost the exact same thing. Interestingly enough, 17 of the cases that have been filed appear to have been settled. I'm looking at that, and of course they don't say what the settlements are, they don't say it's settled, but the cases go away very quickly, and of course they're dismissals filed by the plaintiff. And so my assumption there is that they have reached some very low settlement figure amount, and Mr. Solis is filing on a weekly basis. It seems every week there's another 1 or 2 filings. Interestingly enough, when I look at these complaints, the phone number attached to the complaints are all different. And of course, they're to all different types of companies. This particular one was to a trucking company. You can see the text message over here. I did a copy of one of the text messages so that you can see what it is. It's very clearly a recruitment text message that the individual got. And he said, hey, sorry, let me back up. So what I think is happening is that this particular plaintiff is acquiring used phone numbers. And then when he receives a text message, immediately after he gets the new used phone number, he puts the number on the do not call registry. And then any text messages he gets to that phone number, he then does this and threatens to sue, saying you have violated the TCPA. All the work has been done ahead of time. He already has a complaint drafted and ready to go. And he is, basically engaged in an enterprise of, hey, settle with me for cheaper, because I'll settle cheaper than what it will cost for you to defend this case, and I'll go away. And so he just continues to file these. There are a few that are fighting back, which I was happy to see in these cases, but this is what is happening. And this is the classic case of a serial plaintiff. We've seen these cases under many other laws. The FCRA is one of them, for example, but the TCPA is part of it. This is what's happening. So I wanted to let you all know this is what happened back in July. It affects directly the trucking industry and individuals going after the trucking industry trying to make a quick, well, what they see as a quick, easy buck. So if you will go to the next slide, Molly, what we did shortly after we discovered all of this, you might have seen it, we put up an alert inside the dashboard and we said, hey, users, if you at all have this number associated with your texting list, remove it because it no longer belongs to a driver. So that particular phone number that was at issue did previously belong to a driver. If you use Tenstreet for texting, if you only use Tenstreet for texting, we could tell that no Tenstreet client out of Tenstreet had ever texted that number. Or of course it could have been called, but not from a Tenstreet number. So we know it wasn't texted through Tenstreet. But if you use a third-party texting service, that very well could be a phone number because it was associated with the driver. It used to be associated with the driver, and for whatever reason, the driver no longer has that phone number, and now that phone number is associated with this particular plaintiff, serial plaintiff, who has no qualms about filing a lawsuit. So we put out this alert, said, hey, if you are using a third-party service, make sure you remove this number. We explained the situation and explained, of course, that no text messages had been sent out from Tenstreet to that number. And then we also took action to make sure that no text messages would go out again to that number. So if you're texting only from Tenstreet, that number cannot be texted from Tenstreet. So if you're using Tenstreet, you're good here. And of course, if we find more of these, we will update you as we find these and do the same thing we've done here. The problem is that it's hard to see around the corner and to see in advance when suddenly a phone number is going to be discontinued and no longer a driver's number and received by a serial plaintiff like this. So next slide, please. So that's why we're talking about this. I want to give you the tools that you need to protect yourself as best as you can, and that is getting consent, getting a written opt-in. So that's what we're going to talk about here. Your best defense, your absolute best defense is to get a written opt-in. In this particular case, that particular company and that particular case and phone number, the texting did not go through Tenstreet, while the individual, the subject plaintiff, thought it had gone through Tenstreet. It had not, but it actually gone out through a third-party service, through a different text messaging company. The plaintiff did file in that case against the other company who the particular Tenstreet client used to send out the text messages. So I don't know the specific details about whether consent was had or anything along those lines, but I do know that if they have consent from the driver, even if that phone number has changed hands, and you have a reason to believe that that phone number, you don't know, right? Like how can you know that that number was discontinued? But if you have a express written opt-in and the phone number changes hands and you had every reason to believe that that was still a driver who was still interested in receiving text messages, then you have a really, really, really good defense for sending those text messages. So you don't spend a whole long time in protracted litigation. You know, hopefully you get legal counsel, you get in the case, you explain it to the judge, and you get a quick dismissal. However, that standard is a little fuzzy, right? So let's go through what the specifics are that you need, and then kind of talk through all of that. So there's two kinds of consent. We're going to talk about the other one here in just a minute, but the best one to get is written consent, or an actual authorization from the consumer, from the individual, that says you can text or call me. And it has to have that specified phone number. It has to be clear and conspicuous of what you are doing. Like, I am going to text you at this phone number, right? Or you opting in to receive marketing text messages or marketing communications to the phone number listed, right? So that kind of clear and conspicuous. The FCC has said that it doesn't have to be like a written disclosure and authorization like the FCRA. It can be obtained on a website form, through an email, through a text message, through telephone keys, or a voice recording. So you can obtain that written consent through a number of different ways. It doesn't have to be a very technical consideration, as long as you get sort of those other things. And then if you get that prior express written consent, it is exempt from the check of a do not call registry requirement. So just for clarity's sake, if you don't get the prior written consent, then you do have to check that do not call registry. In fact, you have to check that do not call registry every 31 days and update the records accordingly. But if you get written consent, you are exempt from that do not call registry requirement. And so one other key thing, if you are purchasing leads from a third party and they are representing to you, oh, we've gotten written consent to text this individual or whatever, be very aware. Red flags should be going off, because the written consent must be explicitly given to the sender. So that's one of the things about the TCPA that the law says you have to sort of disclose who it is that's texting. You have to disclose who it is that they've given authorization to. If you're getting it on the Intella app, for example, it's very clear. The individual who is applying to the company on the Intella app is giving authorization to the particular company's Intella app to text them. So that's something that's going to be really clear. But if you purchase leads from somewhere else and the consumer doesn't know who they gave consent to, or that you received those leads, even if they gave the prior person consent, that consent to text doesn't necessarily flow to you. So be very aware and very cautious of that. So some of the other best practices, thank you, Molly, that you should follow, obviously, like we just talked about, get the prior written consent before you text them. Maintain a record of that consent. So be able to go back and say, this individual opted in or gave their written consent on this date. Have a list of all of those individuals who gave that consent. Of course, we can do that for you. There's a very easy report that can be run for all individuals who have opted into texting at Tenstreet. And then 3, make sure that they know they can opt out at any time. Okay, we'll cover how Tenstreet does that here in just a minute. But essentially, the individual needs to know that even though they've opted in, they can opt out at any time. That either text stop or text, opt out, something along those lines to the text messages that they get. And then the 4th thing is you have to honor those opt-outs. Those last 2 are key, that the individual has to be able to opt out and that those opt-outs have to be honored. They are key. Even once you get prior written consent, those apply. So you can get written consent all day long, but if they opt out and you don't honor it, that's going to be something that you're on the hook for. Okay, so one of the ways, if you'll go ahead and switch, thank you, Molly, slides. So on this slide, this is exactly the text message that a individual receives from the Tenstreet text messages. So before you text, you want to have a message that goes out prior to your first text message that says you've subscribed to receive text messages from X, right? So I've blacked out the particular client that this one is from, but it goes out and it tells the individual specifically who that they've subscribed to receive text from, and then it tells them, gives them the information they need. You may opt out at any time by texting stop. Of course, there's a number associated with that. They can just reply to this text message and text stop, or that number they can text stop to. In Tenstreet, this goes out automatically and occurs. So thank you, Molly. We're going to talk about what does Tenstreet do for you. We follow all of these best practices and all of these for our standard texting configurations. If you have changes made, or you have a texting addendum, or you have some other special configuration around texting, which you would know if you do, then these don't apply. But if you've just been set up with Tenstreet standard configurations, this applies, and that means that that message goes out prior to the first text that the subject receives. We also, starting back at the beginning, have the standard written opt-in language on the Untitled app that you can adopt. You can change that language to whatever language you specifically want, because we allow that compliance to be in your hands. You own that compliance, that's your compliance. So of course we recommend you seek legal counsel on it. But we have standard written opt-in language. And then before you go, under the standard texting configurations, before you are allowed to text an individual, we do a check. Has that individual opted in by checking a box on the Untitled app, or texting opt-in, or some other sort of opt-in procedure that they can do through Tenstreet. We will only allow text messages to go out when that written opt-in has occurred. So if an individual has opted out, even after they opted in on the Untitled app, that text message won't be able to go out to them. So that helps protect you, because those opt-outs have to be maintained and have to be protected. And then we maintain a record for you of all the individuals that have consented. You can go pull an easier report. If you don't know how to do that, get in contact with your account manager, or you can email account management at tenstreet.com, and they will get that for you. Obviously, like I said, we send out that message to the phone number prior to receiving that first text, so that they know that they can opt out by texting stop. It also works if they say opt out or other choice words. We will honor those. And then of course, if an individual opts out, like I said, we will not allow you to text them through the Tenstreet system unless they opt in again. So key things here, though, this is in the Tenstreet world. So if you use a third-party texting system, or you use another system and Tenstreet, you need to be really aware that for the most part, and there's ways that I can talk you through, how to opt out an individual if they've opted out on another system. There's specific API configurations, but for the most part, if you are using two different systems to text an individual, if the individual opts out through another system, we don't know that, and we don't have visibility into that at Tenstreet. So you need to make sure you go in and opt that individual out on the Tenstreet system too. If you are just using Tenstreet for all your texting, then you're gonna be good with all of these best practices. But if you're using other systems, if you're using third parties, I just want you to be aware of what the rules are, and you need to maintain a process where you're keeping everything in order for who you can text, who is opted out, so on and so forth. We also have added, next page please. We also have added our new application transparency section in Driver Pulse, which easily allows a driver to opt in to receiving text messages, of course, emails and pulse messages as well. So this is another way that a driver can opt out or opt in. They can go in one specific place and manage all of their opt-ins and opt-outs, so that they can, manage who they want and are interested in receiving text messages to and from. So this is a really, really good thing, both from a compliance standpoint, also from a driver managing their data standpoint. The happier drivers are in their job searches, the better it is for the industry as a whole. And so we've also added this as a way that they can opt into texting or, of course, opt out. And this is in the application transparency section of the Pulse app. All right, so next slide. Thank you, Molly. I want to go through sort of another option that I know a lot of companies in the industry use, but it's a very risky option. So I want to talk you through this. This is not an option that I recommend, and it's not something that I think most people should follow. But if you are talking with legal counsel and they're saying, hey, yep, you can do this, then I want you to know what sort of a risky option is, and that is not getting a written opt-in, not getting that checkbox. And so the law behind that is, it's called prior express consent. And I know that's super confusing because you're saying, well, wait, that sounds like you have consent. Yes, it is consent, but it's not the best form of consent because it's not written consent. So that is a key word there, written consent. So it's that checkbox, it's that explicit opt-in. Having prior express consent means you do not have a written opt-in, you don't have a checkbox. So you get prior express consent by when an individual knowingly releases their phone number, is essentially impliedly giving their invitation or permission to be called or texted at that phone number. So this would be, for example, if you have received the phone number from an individual. In 1992, the FCC issued an order that's saying a person providing their number to another party consents to receiving calls or texts from that party. So it's really key. This is not explicit written consent. And so for telemarketing, marketing, text, and phone calls, this kind of consent is not valid. So that's a really key here for the next thing I'm about to say. You can text another individual with prior express consent as long as it is not for telemarketing, marketing, text messages, or phone calls. So if you'll go to the next page, I'll explain this in a little bit more detail. There are some limited lower court opinions. We're talking district court opinions here, not even circuit court opinions, who have held that a job applicant who provides their phone number meets that 1992 FCC prior express consent standard. These district courts have held, there's one in particular district court that has an opinion that lays this out very clearly, and there's a few others that have followed it. But I want to make it really clear that this is not widely adopted, it is not widely tested, it is very fact-based determinations. But this court did say that recruitment or employment text messages are not advertising or telemarketing messages. They said that recruitment activities are not, quote, promoting the provision of property, goods, or services. So there have been, both in the trucking industry and of course in just other sort of employment related matters, individuals who have said, okay, we're gonna take a riskier option of saying we're gonna text these individuals if they've provided us our phone number, as long as it's for recruitment purposes, based on these lower court opinions. Again, it's a very risky option. I do not recommend it, but it is out there, and it is why you might hear companies or people support the ability to send recruitment text messages without a written opt-in, just based on the individual giving your phone number. However, it's really key here, you must still honor those opt-outs, and you have to stop any calls or texts if an applicant opts out. Also, you have to check against the do not call registry every 31 days to make sure that that individual or that phone number didn't go on the do not call registry. And if they did, then there is a technical violation there. So I want to be really clear, it is an option, and it can follow, if you're very careful, very legal, technically speaking, to where you can send text messages for recruitment purposes without a written opt-in. But I really, really want to caution you here, it's risky, and I would not recommend you do it without running all of the very specific facts and details on what you're doing by an attorney. Okay, so Other considerations that I want to just point out here with these is that if there are third parties that are texting on your behalf, on your company's behalf, beware of that. That ultimate party that is directing the communications is the ultimate one responsible for the TCPA compliance. So if, you know, XYZ Recruiting is sending out text messages on behalf of, I'm just going to use my name, Shannon Trucking. It is ultimately Shannon Trucking's responsibility in a future TCPA lawsuit for the XYZ Recruiting company's you know, text messages that they sent on behalf of Shannon Trucking. So just be very aware of that. If you are using third parties that are texting on your behalf or using your company name, check in with them, make sure you have, you know, it's a good idea to have contractual obligations that they will follow the TCPA and things along those lines. I would just use a lot of caution there, and then make sure you're continuing to monitor their compliance with that, because it's the trucking company that could ultimately be liable there. Okay, one other sort of big new thing that has happened in the TCPA world is that there are a lot of states coming out with TCPA-like laws. Florida is a big one. I'm sure California is right behind them, although we haven't seen it yet. Florida passed a new state TCPA law, and the language doesn't exactly mirror the TCPA. What it says is that you have to have prior express written consent, okay, key word there, written consent for, quote, telephone solicitation. So that is a very, very broad language. It is very untested because it's a new law. I have no idea whether telephone solicitation includes recruitment or not. That's not something that has been tested out yet, although I'm sure it's very quick to come. And it's basically created Florida as a new hotspot for class action cases and plaintiffs to bring, you know, class action lawsuits. So other states are sure to follow this example. In Florida, it makes it a lot riskier because the rules suddenly have shifted and changed. And if you're sending out text messages, if you monitor which states you send to, be very, very, very careful about Florida, and then stay up to date because other states are surely to follow this. And so the previous rules that we thought, you know, might be in place around not getting a written opt-in might not be applicable based on whatever state you're in. However, if you are getting that written opt-in, you are covered and you are good in states like California. So that written opt-in is really, really key to manage your risk here. And I also want to point out that there was a case just last year decided by the U.S. Supreme Court, Facebook versus DeGuid. What this case did, which there's still a whole lot sort of coming downstream from this decision, was it narrowed the definition of what an automatic telephone dialing system is. So specifically, the TCPA applies to auto dialers or ATDS systems. And it had previously, by the Ninth Circuit and some other sort of more liberal circuits, been an expanded definition of what an auto dialer is. And the U.S. Supreme Court decided that case and really honed in and narrowed that definition of what an auto dialer is, which was great. It was great news, but it's really still being sort of, even though they narrowed the definition, everybody's still arguing over what that narrowed definition really means. So the scope of that definition is still really, really undetermined, and it's really a technical fact-based determination on whether something is an auto dialer or isn't an auto dialer. So there was sort of a win, but not enough of a win that you can, you know, throw caution to the wind here. So those are sort of the newest, you know, considerations to be aware of with the TCPA and the rules around consent and you know, sort of your options for texting. Okay, so some takeaways here that I want to talk with you all about. Of course, always get legal advice, especially if you're not using a written opt-in. Go talk to a TCPA attorney. I can give you recommendations. You can comment in you want TCPA attorney recommendations, and I will make sure that you get those. But you want to talk through the very fact-based of, hey, how you are running and managing your texting program. Make sure you are getting an opt-in. If you're using two different systems, they need to work together, or you need to be able to manage both of them in a way to where you're making sure you get an opt-in and that you honor opt-outs through all systems. Obviously, like we talked about, monitor any third parties texting on your behalf. As we previously talked about, beware of purchase leads. Just because a lead that you bought from some other third party said, oh, hey, you know, may have represented to you, you can text them, they've opted in. That opt-in likely does not apply to you as well. Blanket opt-ins aren't allowed. Remember, like I said at the beginning, a consent, an opt-in, you have to consent to the particular company to receive a text. So that opt-in doesn't transfer oftentimes. So be very wary of that. As always, be respectful in your communications. These next two, or really next three, are really key, because these are what make the recipients angry. These are what make them go talk to lawyers. These are what make them sue. Make sure that your communications, as always, are respectful and kind. Even though we don't always get those back from the individuals that we're texting with, make sure that your communications at least are respectful. And what that also means is limit the number of texts and calls that you are sending to a reasonable amount. If you're peppering an individual with, 10 text messages a week, they're not going to be very happy about that. They're likely going to opt out. But also remember that each one of those text messages carries a fine with it. So unless you're sure, like you're really, really sure that that individual has opted in with a written opt-in and can receive text messages, you don't want to send them 10 texts a week. So just be real. That's part of being respectful too. And then of course, only send text messages during reasonable hours, like I talked about, 8 a.m. to 9 p.m. in between those time periods for wherever the recipient is what those mean. So I want to talk just briefly while I'm on this page, sort of talking about respectful communications and limiting calls to the reasonable amount. I get a question a lot about how long is the consent good for? So let's say you get a written opt-in. How long is that good for? Well, that's a really gray area. The consent, the appropriate answer is the consent is good for as long as the consumer still wants to receive text messages. So until they opt out. But also you have to consider, you have to have the reasonable belief that the individual still wants to receive text messages, that they're still consenting to receive calls and text messages. So what that means is, don't text people you haven't had contact with in 10 years. If you have not dealt with a driver in 10 years, it's been 10 years since you've gotten that opt-in and you've had no communication back from the driver in 10 years that they're at all interested in receiving text messages, be really wary of that. And what I'm talking about here is that phone number might not belong to that individual anymore, just like what happened in the serial plaintiffs. And a driver that you haven't spoken with in 10 years or had any dealings with in 10 years is not likely to still want to receive text messages from you. But if you do text them, even though you haven't received an opt-out, know that there is some risk involved there. There is a gray area, and there's gray in, day 1 after the opt-out to day 10. There could be a 5-year reasonable limit on it, right? This is all a gray area of, hey, I got an opt-in from a driver, but I haven't heard from them in 5 years. Do they still want to receive text messages? I don't know. If they haven't gotten an opt-in, do they still have that number? Do you have reason to believe that they don't want to receive text messages from you anymore? Keep all of those things in mind and make sure that you make a business decision in consultation with your legal advisor on those. So those kind of go along with be respectful, be reasonable, things along those lines. So with that, I can take some questions. I hope that you found this knowledgeable. I hope that you all got some good information. And of course, you can always contact your advisor or your account manager and get your answers to questions that you might have as well.
Awesome, thank you, Shannon. Before we jump into the questions, we've had a few kind of like this come in, so maybe we could just clear up what this applies to. There's a couple people who didn't know, like, could they still text their hired drivers after 9 p.m. or before 8 a.m.? Does this apply to marketing and the hiring process, and what happens like once they're on with you, or anything different? Just kind of like what texts and calls this applies to.
Awesome, great question, and thank you for asking that. Yeah, so this does not apply to communications with your current employees that are related to their employment. Okay, so if you're texting or sending even bulk text or mass text out to your employees saying, beware of the weather in Texas, or however you're sending out to your current hired drivers, that's fine. It does not fall under a lot of the restrictions under this TCPA, right? Because you have a right to communicate with your current employees related to their employment. So it doesn't, essentially everything that I said today does not apply to your current employees. If your current employees are opting out, you might want to ask them why and ask them to opt back in. And you can do that because you have the right to communicate with your current employees. The key here is make sure that they are your current employees. And of course, there are other laws which affect the employment relationship, right? So there are wage and hour laws, for example. So if you're texting your employee, hey, you need to be working, doing X, Y, and Z, remember that means they're on the clock suddenly, and you might have to pay them for that. So the TCPA specifically, though, does not come and is not associated with what we're talking about here. And so, yes, I see the first question, can I only text my drivers between 8 a.m. and 9 p.m.? Your hired drivers, you can text whenever you want. You have the, of course, you want to be reasonable about it. Remember that they are your employees, but if they're on the clock and they're employed by you, you have a right to communicate with them however and whenever you need to. So thank you for asking that question and for clarifying that. And I apologize for any confusion around that.
Perfect. And then just one last clarification. So this does apply to candidates that have applied to your position. So texting applicants, you will have to follow these rules?
Yes, that is correct. So highly recommend candidates that apply, if you are sending them even though you're sending them recruitment text messages, still you're gonna want to get a written opt-in. And if you are using Tenstreet standard configurations, because we like to be the most compliant and follow the best practices and set you up to follow the best practices, we will require you to get that prior written consent. Of course, it has to happen through Tenstreet before you can send them text messages. So yes, that applies to drivers that have applied or applicants to your company or individuals that you're sending recruitment text messages to.
Perfect. And then what happens if someone applies through an Intella app, but they opt out of communication? What does Tenstreet do? Is there a way to still contact them legally if they've applied but opted out?
So great question. You should not text them is the answer. And we would not recommend that you text them. You can communicate with them likely via email unless they've unsubscribed from receiving your email. And then there's nothing that prevents you from picking up the phone and calling them as long as you're not using an auto dialer, a quote auto dialer, when you call them. So if it's just you picking up, dialing a number, and calling the individual, the TCPA is not going to apply to that. But if you're using an automated or pre-recorded message, then suddenly the TCPA is gonna come in and apply. Or if you're using some sort of automated dialer to call, like let's say you have some system that just automatically calls all of the numbers that, and Tenstreet doesn't have this capability through phone calls, right? But let's say you just have all the numbers associated with prior applicants that you've received in some sort of system that you can just call, and there's somebody that's just calling them. That would apply, automatically dialing them out to talk to them, to call them. That would apply to those things. But if it's not an auto dialer, you can pick up the phone and call them, but we would not recommend that you text them.
Awesome. And then how would a carrier or someone trying to follow these laws prove that they've checked the do not call list? Or does Tenstreet do that or anything like that?
Tenstreet does not check the do not call list, and here's why. Because if you're using Tenstreet standard configurations, you cannot text an individual that has not given their written consent, and the written consent overrides the do not call list. It's sort of, you're exempt from checking the do not call registry if you have gotten that written consent. So since you can't text somebody through Tenstreet unless they've given written consent, we don't check the do not call list because there's no reason to. If, however, you are using a system, third-party system outside of Tenstreet, or you're using Tenstreet through some non-standard configuration where you can text an individual who has just provided their phone number, right, not given the written consent, but has provided their phone number, then you do need to be checking that national do not call registry every 31 days for that individual's number to make sure that they're no longer on there.
Awesome. And then in Tenstreet standard texting configuration, do we apply the 8 p.m. to 9 p.m. law based off of areas? So for example, if they're texting from New Jersey to a applicant who lives in California, would they be able to follow those time laws through Tenstreet, or would we do anything to help them?
That's a really great question. I am not sure. I don't think we have any limitations on time set up, but I can definitely check. So Molly, please be sure to check whoever's name that is that asked that question and let them know that we'll check on that and get back with them. I don't recall when we set this up that we set any time requirements. I know we set like a limit, like you couldn't text an individual more than some limit a month, like 100 times a month or something, you know, it was pretty far out limit. But I don't know if we put any restrictions around time. So that's a good question.
Perfect. Let's see, I'm trying to go through and see what other questions.
This is great. You guys have had awesome questions. I'm so happy to have had so many people on this webinar. This is just really great. I'm glad that you all are learning about and thinking about your texting compliance, because I think it's something that is not well known in the industry. And hey, why don't we just text them? Is sort of a lot of the times when I'm talking to people, I think the thought process. So like to give the reminder that there are regulations around these things.
Okay, here's one about a third-party vendor and purchasing leads from them. So if they purchase leads from a vendor who specifically states your company's name in the opt-in, would they be covered?
Very, very likely, yes. So if you have a third-party vendor, for example, that this is one of the services that they provide and they get the opt-in specific to your company name, that yes, is very likely to cover you. That's not oftentimes how companies purchase leads, which is why I mentioned it. But yes, if they've already gotten a written opt-in for your company, specific to your company, then you are covered.
Perfect.
But make sure, sorry, let me just say this, make sure that however they got that opt-in, that there are sort of some restrictions in place about monitoring the opt-out, because even if an individual opts in, you still have to honor the opt-out. So just be aware, however you got the leads specific to your company, that you're being careful of and watching the opt-outs.
And then we have a question. I know for standard texting configuration, they're covered, but what about when we're using like Drip or the job board scrubber?
Great question. That is all built in. There are some restrictions around that. If you are going to do texting via Drip, our specific advisors on that side of the house will have a specific conversation with you. If you're wanting to just do a Drip campaign to text your drivers in Tenstreet that have opted in to texting, then it will follow all of the rules. We will monitor all the rules that have opted in and only text those that have opted in. We will send out that first text message, and then we will honor opt-outs. So yes, likely if you, I'm going to put some qualifications around this, because we will, if you come to us and say we wanted text all of these people. We will make you sign a specific legal form, of course, that says you accept all responsibility and liability and yada yada, and then we can just let you text it your will. But if you haven't been presented that, but you're using DRIP only for your opted-in drivers, then yes, that does cover those. And there was another part to that question, Molly, and I've forgotten it already.
Job board scrubber?
Yeah, that's the same. Yeah.
Perfect. And I think you've got it all covered.
Yes, yes.
And then here's a good one. So when they define written consent, so is there a type of document that should be stored in association to this phone number, or how can they keep proof of written consent?
Great question. If you're using the Intella app and they've opted in on the Intella app, then that's your proof right there. It doesn't have to be like a disclosure and authorization like under the FCRA. It doesn't have to be a, hey, we have this exact thing, it's presented in this exact way. There's not those real strict technical things around it. So you can get it in any way as long as it's written. So it can be, you know, check here if you wish to receive marketing text messages and emails from Shannon Trucking. You know, they check that box on the application, and then you have that application saying that they opted in. And then there's also reports and things that you can pull in Tenstreet that show an opt-out. There's under the subject communications view, I believe, there is sort of like green and red indications of what they have opted into receiving and what they have opted out to receiving. So those are all your forms of documentation. It doesn't have to be anything very specific. It doesn't have to be a written signed release. It just has to be, hey, I got this written authorization. And because as we know on the Intella app, they fill that out, they sign it, it's to your company. That's a really, really great way to get the opt-in.
Perfect. And then there's been a couple of questions along the same lines. If they're getting leads from another platform or importing leads into Tenstreet and then using Tenstreet to text those imported leads, do they have a way to get like opt-ins or written consent, or is Tenstreet doing that for them when they're imported? How do they go about that?
If you are importing leads into Tenstreet that you've gotten from somewhere else, they are not opted into receiving text messages. They would have to opt in somehow through the Tenstreet platform to receive text messages from our standard configurations. If you want to go a different route, then you can sign a special piece of paper, you know, a special agreement. You take all responsibility and liability for that. We can get you that, and you can do whatever you want. But if you want to use Tenstreet's configurations and be protected in Tenstreet, the individual needs to somehow opt in on Tenstreet's site. And so the way that we recommend you do that is we recommend you have them text your specific phone number within Tenstreet, opt in. And once they opt in, then you can send them text messages. They also can sign up with the Pulse app and find you, and find, of course, that they are, you know, employed by you on the Pulse app. And I'm not the technical person, I'm the lawyer, so you'll want to talk to an account manager, especially specifically about the technicals of this. And then they can check that green box to opt in to receiving text messages. So those are the ways that they can opt in for imported leads, or they can fill out an application or a short app or something along those lines and check that box to opt in. So there's lots of different ways to get imported leads if you're gonna, you know, want to opt somebody in to be able to text out of Tenstreet with that written opt-in.
Cool. And then is there any way our recruiters, or is anyone notified during or when someone opts in or opts out at all in Tenstreet?
Yeah, so the easiest way is under the subject view, there's a communications view, and you can see there, and I should have included a picture of it with these slides, but there's a way there you can see what the individual has opted into, whether they opted into receiving emails, text messages, or Pulse messages, and then you can unsubscribe them there too. So let's say you're on the phone with a guy and he's very angry that you called him and he says, never call me again. you can go into that communications view and unsubscribe them and opt them out and make sure that they can't get text messages or phone calls from you, of course, in compliance. And so that's a really easy way to see it and a really easy way to manage it.
We actually did have a question. So if an individual asks for an opt-out verbally, does that count? Will they have to honor that always, or is there?
Yes, it does. Technically speaking, yes. If you follow that all the way to fruition, what that would mean is the individual opted out. Yes, verbal opt-out is a valid way to opt out. Of course, you're going to have record of that communication. And so the individual, of course, would have to sue. A TCPA violation. You texted me after I said opt me out. And then you're going to have a particular individual on the stand saying, I told them to opt me out. I was on the phone with them. And then you're going to have another individual saying, I didn't hear them say that, or I did hear them say that. However they answer that question. So that's sort of the evidence that you're looking at. So it's a question of evidence, but technically speaking, if they say, I don't want any more calls or texts from you over the phone, that is a valid opt-out, and you, from a technical perspective, should opt them out and not text them or call them anymore.
Perfect. Just a couple more questions. I don't want to go too late, but we do have a few more really good questions. If a candidate texts them first after seeing a recruitment ad and getting the phone number, are they covered there, or do they still need a written opt-in to talk about recruiting or marketing?
That's a really great question. That is going to fall under sort of the implied. I mean, that's probably written consent, right? If they're texting you interested in it, because you have something in writing, right, on a text message that is opting in. It would be better if you had sort of the legal language around that, right? So this is a gray area of, you're gonna have, two lawyers in a room and get 5 different opinions. So it's definitely something that you want to consult with your attorney about. I think the risks of texting somebody who has texted you interested are very low to text them back, right? They're impliedly wanting to receive recruitment text messages at that point. Of course, you would have to honor any opt-outs, but another lawyer might say, oh no, you didn't get the exact written opt-in language for that to be considered prior written consent. So just know that there's some gray there, but that in general, overall, if somebody's texting you, they are probably, consenting to receive text messages back, unless they say opt out, and then you can't send them any text messages any longer.
Perfect. And we had a couple of questions about opting in during the application process. Does Tenstreet's standard application have an opt-in for this?
Yes, it does. It, I believe, is on the first page. I'm sorry, the first page that they're gathering information, where we get all the personal information. That is where we have all of the sort of checkbox opt-in language there available for you to get. And that comes on our standard Intel app.
Perfect. And I'm going to wrap up with one more question. Is there a reasonable timeline that you have to honor the opt-out in, or is it kind of like automatic? As soon as they opt out, if you send another text that was already scheduled after that or whatnot, would that still violate this law?
There is some timelines. I do not have those in front of me. That's a great question. With most sort of electronic systems now, that doesn't come up because they just automatically, like if that's the case through Tenstreet, if let's say you have a drip campaign scheduled for those who have received opt-ins and the individual opts out 2 minutes before the drip campaign is set to go out, ours will not continue to send that out. But if you've got a third-party system or some other system, there is a time limit. I don't have those in front of me. It is a reasonable time. So if it's within 2 minutes, you're covered. You're safe. I don't even want to say a number of days because I'm just guessing, but there is a reasonable time period there after the opt-out that you have to sort of remove them from your systems and all of your systems. I can get back with you on the specific days. That's not hard to find.
Perfect. Well, I don't want to go too far over. I did have a few questions about being able to review this later. So I did want to remind everyone that tomorrow around 3:00 p.m. Central Time, you will receive the recorded webinar in your email inbox. So you can watch this as many times as you'd like, share it with whoever you'd like, and you'll get to review it as many times as you need to and check all the slides, find all the information. But I think that's all I had. Shannon, did you have anything else before we signed off?
No, I didn't. Thank you, everybody. I appreciate you spending your Thursday afternoon with me for a little bit to learn about texting. Have a great day, everyone.
Thanks, everyone. Bye-bye.